Good morning, Monmouth and Ocean counties, and to the rest of the world out there listening in on the internet. I'm Doug Hull of the law firm of Novy and Associates. As you know, we're the law firm that specializes in elder law, which includes asset protection, Medicaid planning, guardianships, trust and estate planning, administration, and litigation. And you're listening to Inside the Law on 1160 WOBM AM in Ocean County and 1310 AM in Monmouth County, and it's available all over the world on WOBMAM.com. You know the format. Each show we take you, the listener, inside the law to learn about an issue or a topic of interest. Today, we're doing a pre-recorded show so that you will not be able to call in with any questions, and we hope that the information that we're providing today will be of assistance to you. Today we're going to be talking about guardianships. Now, if anything that we cover on the show today raises a question in your mind, or you have a question about some other topic, please feel free to call our office at 732-657-0600. We'll be glad to try to address your question or possibly use a question you might have on a future show. Now, today I have with me Jake Mason, who's our marketing guru at Novy and Associates, and Jake's going to be kind of leading us through the guardianship topic. Jake, how are you this morning?
I'm doing well, Doug. How are you?
I'm just fine, thanks. As long as my voice holds out with all this pollen that's been in the air, I'm sure a lot of our listeners are having a similar experience. So what do you have for us today?
Well, Doug, I think just the kind of a leading question, a little softball here. What is a guardianship?
Well, a guardianship in its most basic terms is a process whereby one person or sometimes an entity gets appointed to handle the affairs of another person.
Okay, so is a guardianship action filed if someone becomes incompetent?
Okay, that's certainly one of the times that a guardianship action could be appropriate. Ocean County has far and away the highest volume of guardianships in the state of New Jersey, and one of the reasons for that is that Ocean County probably has the greatest number of senior citizens in the state of New Jersey, and it's no secret that as people age and get older and older, the time could come where their mental capacities are not what they used to be, and that's certainly not a universal truth by any stretch, but it is a practical reality. So, bearing that in mind, there are a lot of guardianship actions filed in New Jersey, filed in Ocean County. Now, you use the term incompetent, and incompetent is still, I think, a realistic term, but it's not the term of art. The term that is now used in the statutes and court rules is an incapacitated person, and the person could be incapacitated by reason of illness, mental defect, or other conditions. But that's certainly one time that you might need a guardian. Now, a lot of times when they're talking about guardians of an incapacitated person, sometimes people will kind of just make the assumption that that takes place because of the fact that a person has become older, has suffered a stroke, had some other debilitating condition, not the least of which is some form of dementia. But it's also possible for an incapacitated person to have a mental condition, which they may well have had from birth or from early on in their life. Sometimes you will have a child who has had some form of a disability, and while the child is a minor, the parent has handled everything. Now the child is reaching majority, is turning 18, and now they're going to be viewed, at least under the law, as an adult, and they are not able to handle their affairs. So it's also sometimes that coinciding with the minors turning 18, the parents will file a guardianship action to become their child's guardian. Another possible time when a guardianship action could be filed relates to what is called a special medical guardianship, and this is a somewhat limited, relatively unusual situation, but it exists, and it's designed for a situation where you have a person who has some significant medical issue. Maybe it's possible surgery or something of that nature, and the feeling exists that the person may not be in a condition to make informed decisions about their medical care or the treatment plan, and they have not had a medical power of attorney done, to name somebody to make the medical decisions for them. So sometimes either a private individual, whether it be a family member or not, or sometimes the actual medical facility itself, will make an application to the court to have someone appointed as a special medical guardian. There will typically be an accelerated hearing, for this, because very often the medical conditions are such that action needs to be taken. So you can't be delaying moving forward with this, but the court can appoint somebody as the special medical guardian. The procedure will then be done, not be done, whatever is deemed to be appropriate. And then if the procedure is successful and the person is restored to capacity, thereafter the guardianship just terminates, and the person proceeds hopefully on his or her merry way.
And Doug, you talked a lot about spouses and parents in these situations. Do these spouses and these parents automatically have the power to act and to act on behalf of the child or their spouse?
No, they don't, and that's really a very popular and unfortunate misconception, because a lot of times we've had people come into the office and they explain what the problem is, and then they follow it up by saying, now, I'm the husband or I'm the wife or I'm the parent, so I have the ability to act for him or her, right? And unfortunately, we have to explain to them that the answer to that is no. There is nothing in the law that gives someone else of a family relationship the power to act for the other family member in an issue of incapacity. Now, I had talked about parent and child, and while the child is still a minor, as a general rule, the natural parent has the legal right to take action in the best interest of a minor child as it relates to the person. The law kind of views this whole guardianship arena in two different aspects. One is the person, and the other is the property. So a natural parent is the natural guardian of the person of their minor child. So if a decision comes up, does the child need medical treatment? Should the child go to this school or to that school? Those decisions are within the power of the natural child of the natural parent to make those calls. If you're talking about finances, it's the parent has a much more limited power. You might think that a parent raising their child has been given the opportunity to spend a lot of money for the care of their child, and they certainly can spend that as long as it's their own money. It becomes a little bit of a different situation when the money is in fact the child's money, and it is coming to the child either by reason of an inheritance. They've had the misfortune of suffering a personal injury, and there's a lawsuit, and there's going to be a recovery, from the lawsuit. If any monies are coming in those respects, where it's viewed as the asset of the child, there is a very significant limit on the parent's ability to deal with those funds. Basically, the standard is $5,000. If a child is going to be receiving less than $5,000, the law allows payors, banks, etc., to pay that money over to the natural parent. If it's more than $5,000, then they can't do that, and it unfortunately becomes a situation where the parent may well have to go to the court and seek to be appointed the guardian of the funds of their child. Now, so long as we don't have any big matrimonial dispute here, or have a situation where one of the parents has been indicted for some kind of a crime, or has been shown to be an unfit parent or something like that. In the vast majority of cases, the court will appoint the parent to serve as the guardian for their minor child's property, and they'll then act thereafter. Now, one thing that you should be aware of, our listeners should be aware of, is that if you have a parent who has been appointed as the guardian of their child's funds, and then the child turns 18, at that point the guardianship would terminate, and it would then be part of the task of the parent to turn the funds over to their child, who is now an adult.
And who initiates the guardianship action?
The guardianship, regardless of which type it is, can be initiated by a number of different people or entities. Far and away, family is the most likely source that would be filing for a guardianship. And if there's a parent and you're talking about seeking to become the guardian of the child, assuming of course the child is not married, the parent is the most likely person to be initiating it. In the case of a husband and wife, the spouse is the most likely person to be initiating it. If you have a situation where you have a widow or a widower who has children, the children would be the most likely initiating party. Sometimes you don't have that degree of relationship out there, so you may have a more distant relative filing the action. If there's no relative around, you may have a friend doing it. Now, in all of these situations, we're talking about people initiating it, but it doesn't have to be a person. You can have a situation where a person is in a facility, whether it's a hospital, a long-term care facility, such as a rehabilitation center, a nursing home, assisted living facility, and the facility becomes aware of the fact that there is now a lack of capacity and that things need to be done to protect this person or this person's assets. The facility can actually initiate the action seeking to have a guardian appointed. One other frequently encountered source as far as initiating a guardianship is the Adult Protective Services office within the county in question. Each of the counties in New Jersey has a board of social services, and within the board of social services there is an adult protective services unit. It's the task of that unit to make sure that people are protected from exploitation or from harm to themselves. So it's possible for a person to contact the APS unit in the appropriate county, make them aware that there is a person out there who the caller feels is at risk, and the APS office will investigate the situation, and if they find it to be appropriate, they can then undertake whatever action they feel is warranted for the care and protection of the person. One of those authorized actions would be to file a guardianship action seeking to have a guardian appointed for the person.
And now, Doug, when I know you touched on this a little bit, but is there a certain point when guardianships are usually filed?
Okay. The guardianship can be filed at the time that the need for it is recognized. So, dealing with a couple of different situations. I talked about a guardian being appointed when a child who, as a minor, lacked capacity, both by reason of being a minor and because of some emotional, intellectual, or whatever issue. Now that child is turning 18 and the law is looking at the child as an adult. Very commonly, it will be, you'll have a guardianship action filed kind of to coincide with the person turning 18, because the parent recognizes that at that point the parent will no longer be able to sign everything for their child, and want to make sure that they have all the ducks in a row, so that if a problem comes up, they're not then rushing around to get this done. That being said, it's not unheard of by any stretch. Matter of fact, sometimes it leaves me shaking my head how the people can get this far. It's not unheard of for people to handle everything for their child for a significant period of time after the child turned 18, despite the fact that the child has no capacity to act. And I think part of that, at least going back in time, was that people wanted to keep these types of situations on the quiet. They didn't want people to know that their child had issues. The child may not have been going to a regular school or whatever, and they just kind of handled things. And if they got really lucky, they would have a situation where they had a sympathetic doctor who would continue to talk to the parent despite the fact that the child was now an adult. You didn't have any really acute medical issues that required consent to surgery. The child was not going to any facility or enrolling in any program that required somebody to have legal authority to act for them. They were just kind of taken care of at home. And then all of a sudden something happened, whether it, maybe the child needed surgery or whatever, and all of a sudden they had to hurry up and do a guardianship, in order to get the authority to act. But I would say that in these days, in the case of minors, incapacitated minors, becoming 18 and now becoming incapacitated adults, you're usually talking about doing it pretty soon after turning 18. When you're dealing with a situation where it's an adult who has become incapacitated, whether that be by reason of dementia, which is often very progressive. A person doesn't typically start with acute dementia. They may have mildly diminished capacities, and then it just kind of gets worse and worse. Or sometimes you can have an acute condition where a person suffers a stroke or has some other situation like that. But when the person becomes sufficiently incapacitated that there's a problem, is usually when all of a sudden people say, "Oh, I guess we better, do something now. This surgery needs to be done. This stock needs to be sold. We need to do this with the house." Whatever the circumstances are, but there's typically something like that all of a sudden makes the person say, I better get on the stick here and do what needs to be done.
And where can you go to file a guardianship?
Guardianships are handled in two different courts, but each of the counties has both of these types of courts. It's either in the county surrogates court or in the superior court in the particular county. Those are the two courts within the system that handle guardianship actions. Excuse me. If you have something where it's, let's say a guardian of for a minor, and it's totally unopposed, it's the parents seeking it. By and large, you would go through the surrogate, and the surrogate would walk you through the process. If it is a guardian of an incapacitated person, that is certainly done through the superior court, and there's a very detailed process as far as how you go through the procedure of having a guardian appointed.
And who does the court usually appoint as the guardian?
There it all depends. Under the law in New Jersey, there's what is, for lack of a better term, a pecking order as far as who should be appointed as the guardian. Now, this pecking order isn't something that the court is forced to follow, but it is certainly the preference, unless there's some good reason to deviate from that. And the pecking order is really what I think most people would logically view to be the case. So if a person is married, their spouse is typically going to be the person who has the first right to serve. If the person is not married but they have children, the children are going to have the first right to serve. If you're dealing in a situation where you're dealing with an adult child and there are one or more parents, the parent is the typical choice, and you can then go down with more distant relations from there. Now, just because this is what the pecking order says, that isn't what it has to be. So sometimes you'll have a situation where you might have a married couple. They're both of advanced years. You might have one who is incapacitated, and the other has his or her own limitations, whether it's poor health, some medical condition that makes it troublesome for them to handle this, something along those lines. They might say, look, I know I have the right to serve, but I want to do what is best for my husband. So instead of appointing me, we have children, and I would like you to appoint one of my children, and the other two children are on board with this. They agree that this is what's best. Absent there being something strange about the situation, the court would go along with that, because frankly there's no reason not to. If the family as a unified group thinks this is what's best, the court is very likely to go along with that. Sometimes you'll have a situation where the family members opt to do battle about who should serve. So, using the example I just gave, you have the wife say, well, I don't think I should do it because I'm not physically or mentally up to it. I have 3 kids. Appoint one of them. And you then have 2 of the kids start fighting about who should get appointed. When I said that you go down this pecking order, when you get to a level where there might be multiple people in that that level of relationship, they each have an equal right to serve. Now, if you had two children at that level and the two of them get along really well, they could ask the court to appoint them as co-guardians, and that would be fine. If, on the other hand, you have the two children who don't get along very well, the court may say, okay, why don't you, just kind of grow up, do what's best for your parent, and, make this work. Sometimes the children will get their act together and will agree to that. Other times their discord is such that that's just not going to work. The court in those circumstances is generally not inclined. This isn't a universal truth, but is generally not inclined to pick one over the other, absent there being some real good reason for doing so, because they know that it's going to create a situation where the one that was not appointed is going to complain about everything that the sibling does as guardian, and may wind up just dragging the matter back into court to complain about things. So sometimes in those situations, the court will say, look, if you can't reach agreement and agree to work together, I'm not going to appoint either of you. And when that happens, the court can either appoint a disinterested third party, or there is actually a state agency, which is called the Office of the Public Guardian, that the court could appoint the Office of the Public Guardian to serve as the guardian. The OPG will typically assign one staff attorney and one staff social worker to each particular case, and then they would go ahead and deal with the care of the person going forward.
What kind of safeguards are in the system, or does the system contain, to make sure that either the wrong guardian isn't appointed, or that that the person that needs a guardianship does have someone to act on their behalf?
Well, there are a number of things, both during the course of the guardianship action and after the appointment of the guardian. The first thing is that in order to move forward with the guardianship, the party who's bringing the action, who's seeking the relief from the court, must have reports from two physicians indicating that they have examined the person, and that based upon their medical opinion, the person is unable to effectively manage their own affairs, which is what the test is for whether a person needs a guardian. So you start with having those medical proofs submitted to the court. The court will also appoint someone, an attorney, to represent the interests of the alleged incapacitated person. That court-appointed attorney's job is to go out and meet with the alleged, incapacitated person, to try to explain to them what a guardianship action is all about, and to try to find out whether the person agrees that the appointment of a guardian would be appropriate, or if they have some problem with it, find out what the nature of the problem is, and is it that they object to a guardianship per se, or are they just objecting to who is being proposed as the guardian? Now, one thing that's important is that the court-appointed attorney's allegiance is to the person for whom they have been appointed. So if you're saying that Mr. Jones is an incapacitated person, the attorney for Mr. Jones is supposed to, unless it's totally ridiculous, is to follow the wishes of their client. So if Mr. Jones says, look, I may need a guardian, but the person seeking to become my guardian is my son, Tom, appoint anybody you want, but not Tom, then the court-appointed attorney is supposed to make that known to the court. Sometimes Mr. Jones says, I don't need a guardian. I'm fine. But every indication out there is that, no, Mr. Jones really does need a guardian. There, the court-appointed attorney is kind of in a very delicate situation because they're supposed to be doing what their client wants, but on the other hand, they want to see what's best for their client. So sometimes a situation comes to exist where they have to basically let the court know that there may be an issue out there where the court may need more information, and that they're not the proper party to be giving this information. So the court can actually appoint another person as what is called a guardian ad litem, and that person would have the task of meeting with the person, investigating the situation, and basically reporting back to the court about what he or she feels is in the best interest of the incapacitated person, to try to just have an extra set of eyes and ears involved. In addition to those protections that take place during the process, afterwards there are also protections. First of all, the guardian has to be bonded. So this makes sure that if the guardian were to improperly abscond with the funds of the incapacitated person, or take some action that was so foolish that it resulted in damage of some kind, that there would be a fund available to make the incapacitated person whole. The premium for this bond, which is an annual premium, is based upon the dollar amount involved. The greater the amount of assets, the higher the amount of the premium, and it is an annual premium. So long as a guardian remains in effect, the premium would continue to have to be paid. If the assets were to get down below $10,000, then the court can thereafter waive the requirement of bonding. Another protection is what they call an accounting process. Now, the guardian is supposed to file an annual report with the surrogate as far as the well-being of their ward. The ward is the incapacitated person. Basically saying where the person is currently living, and how he or she is doing, that kind of thing. But from a financial standpoint, they're supposed to be filing an accounting. Accountings can either be what are called informal or formal. Given a choice between the two, you definitely want an informal accounting because it is far less expensive. Both ways, it gets filed with the surrogate. It basically is done on an annual basis. You show what assets existed at the beginning of the accounting year. You show what additional assets may have come in. You show what income has come in during the year. You then show what expenses have been incurred, during the year. What bills have been paid, and then you then show what, from an accounting standpoint, should be the amount remaining. On a separate list, you show what assets in fact exist, and those two lists at the end better darn well match. And if they don't, then there's some problem. Ocean County has a number of people in the surrogate's court whose task is to review accountings. They're accountants by profession, so they certainly know what they're doing, and they go over these accountings with a fine-tooth comb to make sure that they're set up properly. Jake, if I can, before we go on to the next question, I'd just like to remind our listeners that if anyone out there is a member of a civic group or organization and is interested in having someone come to speak to their group, please contact our office at 732-657-0600, and that can be of a legal nature, or our office is a member of a group called the Senior Resource Alliance. This is a group of local businesses that specialize in senior needs, and it includes caregivers, independent and assisted living and nursing home care, real estate, movers, financial advisors, prepaid funerals. So if anyone wishes to have a presentation given by any of those categories, you can call us at 732-657-0600, and frankly, you'll probably wind up speaking to Jake, and he'll try to put that together for you. If you wish to contact us, you can do it at the phone number that I gave. You can also contact us through the website, which is www.novylaw.com. And we do have offices in both Ocean and Monmouth counties. The Ocean County office is at 2915 Ridgeway Road in Manchester, and the Monmouth County office is at 2150 Highway 35, which is the Brook 35 Plaza in Seagirt.
And Doug, real quickly, I just want to make a public service announcement. Our friend Pam Montemirno, who's been a guest on the show before, over at Bailey, they are hosting Congressman Tom MacArthur from New Jersey's 3rd District. That's going to be on June 8th at 1 p.m. over at Bailey Health and Rehab. Rehab and Nursing, excuse me. And he's going to be talking about some of the challenges in healthcare and some of his perspectives on the changes in Medicaid and Social Security. If anybody is interested in registering for that, they can call over to Bailey at 732-240-0090, and you can ask for Dimitri. Again, that's going to be June 8th at 1 p.m., and it's going to be Congressman Tom MacArthur from New Jersey's 3rd District.
Great.
And getting back on track here, talking about guardianships again, does a guardian take control of all aspects of the person's life?
Okay, that all depends on what the judge has determined as part of the guardianship process. If a person is appointed as the full guardian, they would have the full authority to make all of the decisions with regard to their ward's, care, living arrangements, finances, etc. But sometimes the court will impose limitations because the general philosophy of the guardianship statutes are such that the person should have as much control over their own life as is possible. So sometimes the court will carve out subject matters and say, yeah, well, I'm going to appoint a guardian for you because I think you are, God bless you.
Thank you.
Because I think you're unable to handle all of your affairs. There are certain things that I think you are able to handle, and I want to have at least your input. Probably the most commonly found situation there is a person's living arrangements. It's not at all uncommon to have a a parent or Uncle Harry or whoever, where a guardianship action has been filed and the court-appointed attorney goes out there to talk to them, to have the person say, look, maybe I do need help. And the person who's being proposed as my guardian, if I have to have one, that person's fine. But I've really got a concern about where I'm going to be living. I'm really afraid that they're going to put me into a nursing home, or I'm afraid that they're going to, send me to such and such a place. I just want to live at home. I've lived in this house for a long period of time. I'm used to it. I like it. I like the people around here. I just want some assurance that I'll continue to live there. Now, unfortunately, life being, what it is, we don't know what's around the next corner. So around the next corner, there could be a real serious, physical, medical problem where the person needs care in a long-term care facility. But if today the person is okay living at home, maybe with a 24/7 caregiver or some protective arrangement, it's not uncommon for the judge to put in the order a provision saying that the person will not be removed from the home without further order of the court, so that if the guardian feels that the person should be moved, needs to be moved, they would have to go back to the judge to explain why they think this is appropriate. You have sometimes situations where, and this may sound strange, but I've had it come up a number of times where the person says, yes, I might need a guardian, but it's really important to me that I be able to vote. I just want to vote. So you might have the court put a provision in saying, well, this otherwise incapacitated person, we're going to carve out their right to continue to vote. You can have any things along those lines. It's sometimes they'll put a provision in there while the person should not have control over their funds because they've already frittered away large sums of money. More times than I care to recollect, we've had situations where either a person has given away significant amounts of money to various charities where they really didn't have the excess money to be giving it away, or they've bought much more stuff on Home Shopping Network or whatever than they should have, and they've really jeopardized their finances. Sometimes the court will say, all right, we need a guardian in place to take care of the big picture. But the person is concerned about having some pocket money so that, he can go to his, favorite, church and make a little, donation on Sunday, or he could go down to the local bar and, meet with his friends and have a beer or something like that. So sometimes the court will put a provision in that the person will be given an allowance. One other kind of procedure that exists is if you have a situation where the person comes in and kind of admits, I think I need some help. I'm not at the top of my game, but on the other hand, I don't think I'm incapacitated either, and can demonstrate to the court that may well be the case. There's another procedure available, which is called a conservatorship, and the person who is appointed to assist the person, and their title is a conservator, really only has the authority to act for so long as the person who they're assisting is in agreement that this is a good situation. The person has the ability to say, this isn't working out, so well. I think you're being too pushy. I think you're being a pain in the neck, whatever. So we're going to cancel this. So the person would have the ability to terminate the conservatorship. That being said, if the other people involved think that maybe their condition, maybe the person's condition has deteriorated, and now they do meet the requirements for a full guardianship, then a full guardianship could be filed at that point.
And Doug, just one last question here as we kind of wind down in the last 5 minutes of our show. Everything that you've talked about a guardianship seems to be it takes away a person's rights. But are there ways to deal with the problem of getting assistance without filing of a guardianship?
Sure, if the circumstances are appropriate. I mean, far and away, the most commonly used technique is by having a properly prepared power of attorney. Now, you can have powers of attorney that deal with just finances. You can have them deal with just medical, or you can have a general power of attorney that does both. You can have powers of attorney that are sometimes called springing powers that only take effect in the event of the disability or incapacity of the person who is signing the power of attorney. More commonly, you have what is called a durable power of attorney, which takes effect at the time of the signing of it and remains in effect even if the person subsequently becomes disabled or incapacitated. For a long period of time, the law in New Jersey was such that if I gave you power of attorney to act for me, and then I became disabled or incapacitated, the power of attorney ceased to have any effect by operation of law. And then finally, the state legislature said, wait a minute, that may be the exact situation where you most needed somebody to act for you, and you most wanted somebody to act for you. So they basically said that a person can make their power of attorney durable, and it would continue in effect even if there was a subsequent disability or incapacity, but you have to state in the power of attorney that is your desire. So all of that being said, a power of attorney is a relatively inexpensive, easy process for appointing whoever it is that you want and who is willing to do it, to have the power to take action for you. The difference between the power of attorney and the guardianship is that under the power of attorney, you still have the ability to act for yourself. So you're naming so-and-so as your agent, but you still can act for yourself. Sometimes the power of attorney isn't working because you have this agent who is seeking to do the right thing and take the right action for the person, but the other person, the person who gave the power, is not really in a good mental condition, and they're undoing all the good done by the agent. So, for example, dad gives daughter power of attorney. Daughter says, and from a medical standpoint and financial standpoint, daughter is absolutely right. Dad would be best cared for in this facility. Dad doesn't agree, so dad signs himself out. Daughter convinces him that he should really give it another try. He goes back in. A day later, he signs himself out again. Well, sometimes these people are seriously at risk. and sometimes a guardianship action becomes necessary in order to take away the person's ability to continue to act for themselves. There are also sometimes situations where a person might name their two kids under a power of attorney. One of the children passes away, the other one has a stroke and is unable to act, and there's really nothing in there that appoints a substitute. Sometimes if the parent is now sufficiently incapacitated that they can't do a new power of attorney, they might have to do a guardianship just to, fill in the hole.
All right. Well, thank you very much, Doug. I thought that was a very enlightening talk and on what some might consider a grim topic.
Well, it's grim, but unfortunately, there are a lot of situations out there that people would prefer not to think about, prefer not to deal with, but preparation allows for better handling of the situation.
Well said. And we'll be back on the air June 6th. Bob Novy will be on with Vicky Cox. That will be part one of a two-part series on aging in place, and we'll be talking about geriatric care management. If any of our listeners have any questions about this show or any other shows, please give our office a call at 732-657-0600.
Thank you. Have a great weekend, everybody.
Enjoy
Bye-bye.
Memorial Day. Bye-bye.